How about off-season restaurant deals? Anyone got any? Free parking? Damn, not gonna happen. We wish. Today, we are going to be talking about everyone's favorite topics, FOIA and ethics. What is FOIA? Commonly known as the Freedom of Information Act. We refer to it as FOIA. It is fundamentally important. Has two components, open meetings and open records. That sounds very simple, very basic, really easy to understand, but I'm here to tell you that there are tricky questions presented by FOIA. There are answers that are not necessarily logical, practical, or simple, so that is why we are going to review this. What is the public policy of FOIA? I'm going to read it because I think it's important to understand. It's vital in a democratic society that public business be performed in an open and public manner so that our citizens shall have the opportunity to observe the performance of public officials and to monitor the decisions that are made by such officials in formulating and executing public policy. And it is vital that the citizens have easy access to public records in order that the society remain free and democratic. That is a long way of saying open meetings, public documents. Open meetings. Public bodies are required to have open meetings. Who's a public body? Well, the Board of Commissioners, the Planning Commission, the Board of Adjustment are clearly public bodies. But the statute has far, far broader reach. A public body includes any regulatory, administrative, advisory, executive, appointive, or legislative body of any political subdivision of the state. Let me reiterate. It means any board, bureau, commission, department, agency, committee, ad hoc committee, special committee, temporary committee, task force, advisory board, subcommittee, legislative committee, association, group, panel, council, or any other entity or body I forgot. You are all subject to FOIA. Public bodies. The general rule, subject to a few exceptions, is that every meeting of all public bodies shall be open to the public. If there is doubt about anything, the discussion in the meeting should be in the public and follow the statute. Meetings should also be held within the jurisdiction of the public body, which is why many, if not all, of our meetings are held here. In order to have a public meeting, you must provide notice of the public meeting. All public bodies shall give public notice of their regular meetings and of their intent to hold executive session at least 7 days in advance thereof. The notice shall include the agenda, if such has been determined at the time, and the date and time and place of such meetings. Regularly scheduled meeting means any meeting of a public body. Board of Commissioners, for example, we have workshop meetings and we have regular meetings. They are all, for the sake of FOIA, regular meetings. What should be in the notice and where should it be? Public notice is a conspicuous posting of notice. You will note downstairs on the bulletin board there are all the notices. Excuse me, and it needs to say the date, the time, and where the meeting is being held. All public bodies shall give this same public notice of any special or rescheduled meeting as soon as reasonably possible, but in any event, no later than 24 hours before such a meeting. A special or rescheduled meeting is defined as one to be held less than 7 days after the scheduling decision is made. And the agenda or notice should explain in great detail why 7 days notice could not be given. We have a public body, we have notice, and attached to that notice should be the agenda. Agendas are required for all meetings. An agenda for a public meeting must include a clear and concise statement of the items to be discussed or acted upon, sufficient to give the public reasonable notice of the matters that will come before the body. It must also contain a statement of intent to hold an executive session and the specific grounds on which the meeting is being held, meaning the executive session. The statute provides that the agenda shall be subject to change, but it cannot be changed except for certain good cause. How can we change agendas? Additional items, including an executive session, which arise at the time of the public body's meeting, can be included by amendment at such meeting, and the reasons need to be explained. Items can be deleted, including an executive session, but the addition or change must arise from an emergency or an unreasonably unforeseen circumstance. Administrative convenience is not one of those reasons, but the agenda can be amended to include correspondence or support documents as needed. When the agenda is not available as of the time of the initial posting of the public notice, it must be added to the notice at least 6 hours in advance. And the reasons for the delay in posting must be briefly set forth. So, there is flexibility in agenda for matters that come up after the initial posting, but that should not be the norm. Okay, here's a hypothetical. Let's have some fun. What happens if a commissioner requests that an ordinance be placed on the agenda with less than 7 days' notice and doesn't give a reason? Carolyn?
You shouldn't be adding it.
Nope.
There's no reason you can't add it.
There you go. What about a request for an executive session if there is a valid reason given? An emergency situation, if you will.
Yes.
Thank you. Well, we're done. No, just kidding. All right, so we have a meeting. We have a public body. We have notice. We have a meeting. We are appropriately in the time for public comment. I want to spend a little time on public comment because that seems to be a topic of conversation. A meeting that is open to the public under paragraph A1 of this section must include time for public comment, unless the meeting is of a public body within the General Assembly, which is governed by the rules of proceedings adopted under Section 9 of Article 2 of the Delaware Constitution. We are none of those things. Public comment is at every regularly scheduled meeting. The time for public comment must provide a meaningful opportunity for the public to engage with the public body. However, you can impose reasonable time, place, and manner restrictions on the length of the public comment period and the amount of time allotted for each public comment. The Board of Commissioners, we have established a practice whereby we allow individuals 3 minutes. This allows for everyone to be able to talk, and it does comply with the rules to impose reasonable time, place, and manner restrictions. Once we have the meeting and we've had the agenda and the notice and the public comment, there are minutes. Minutes are always required. Minutes must include a record of those members present and a record by individual members of each vote taken and action agreed upon. It is not a verbatim transcript of what has transpired. Minutes of executive sessions must also be taken, and those minutes are considered public record so long as public disclosure would defeat the lawful purpose of the executive session, but no longer. Meaning, unless and until the matter that was discussed at executive session has been made public, those minutes also remain confidential. All right, I'm going to spend a little time talking about what not to do. Because a violation of FOIA sends us, the city of Rehoboth Beach, to the Attorney General's office, and frankly, that's not where we want to be. So, one of the big issues that have risen is called serial quorum. Does anybody know what serial quorum is? Karen?
Like one person talks to another one, but not the two together, and you eventually end up with a quorum of people being involved in the conversation, whether they knew it or not.
Yes. Like, for example, if you see 2 people standing on the street corner and they happen to be talking about something, and then they turn to the third person and tell that third person. These are the basic things. You don't even know you're doing it, but you are doing it. So we need to be very mindful. FOIA prohibits a quorum of a public body from deliberating public business outside a public meeting, period. End of discussion. It's also called a rolling quorum, which occurs when members communicate one by one or in small groups or in a way that collectively equals a quorum and advances discussion or decision-making outside of the public body's noticed meeting. It doesn't matter that all members are never on the same call or email together, never standing on the straight corner. The law looks at the aggregate effect. Yes?
How many are in a quorum? Is it always one more than half?
One more than half. So yes. Good way of looking, yes. Examples of what not to do. Do not send an email that says, I intend to oppose item 5. Please respond if you agree so we can stop it. I know these are, you wouldn't do this, but just humor me for a minute. I'm trying to make it so you remember. Do not text fellow members during a recess. We have 4 votes. Let's kill this when we go back. Do not poll members individually before a meeting. If I move X, will you support it? Need to know before I make the motion. Do not use intermediaries. Can you go ask the other 2 if they'll vote yes so I know whether to bring it up or not? All not to do. You can just read through these email chains, call trees, hub and spoke, use of a proxy or a messenger, group text before, during meetings. Please don't do this. Just to be clear, anyone not understand what I'm saying? Okay, again, we're done. This is great. All right, beach break. I'm sorry.
Question on that. That is between elected or appointed officials. That does not deal with staff members. Is that correct?
It is with elected officials. However, if staff members cannot be the intermediaries, but yes. All right, beach break. Sorry.
Question. So go back to that quorum thing again. So if I'm having a conversation.
That's a good question. Ooh,
I'm
whoops.
having a conversation.
How do I go back? I'm sorry.
Okay.
I don't know how to do this. I don't know how to do this. Okay, sorry. One more.
Whatever, it doesn't matter. So if I'm having a conversation with the mayor about something, and it's just he and I, that's okay. Or if I'm having a conversation with one commissioner, but once you get 4 commissioners and you're all having that same conversation, then
Bad.
that's a problem.
Yes.
But one-on-one.
One-on-one is fine, but what you can't do is say, I spoke to the mayor and he thinks this when you're talking to the next commissioner.
Correct.
Right? We can't appear to have had a meeting of some kind.
Email communications amongst an entire group
Yep.
is considered public information because someone could see emails and request them.
Yep.
Is that not able to be done, to have discussions through
No.
email with a public group?
No. You should not be having reply all, for example. Don't touch it. Don't use it. It's a bad idea. We should not be replying all to a meeting, an email that comes out to whatever entity you're a part of. You can give information out, but there shouldn't be reply all that includes things like, well, I don't really like this and I don't like that, and so I'm not going to do this. Yes.
The topic has to be on the business subject. In other words, I can send out to a committee and say, can you all make a meeting Sunday? And they can say, yes, they can.
Yes, exactly.
It matters what the topic is.
Yes.
matters
You are
what
not
the
if you
topic is.
if it is something that would come before the public body, a topic of conversation. No, you cannot discuss it outside of a regularly scheduled meeting, but yes, scheduling is fine.
And I would say a good example of this is a resident may send an email out to all 7 members of the Board of Commissioners. That's perfectly fine. They're letting all of them know what their position is. But if a commissioner was to respond to all saying, my point of view on this is I agree with you, this is how I'm going to vote, and then that creates a problem.
And everybody else weighs in, don't do that. Don't do that.
What about a commissioner sending that? Can a commissioner send a note to all the other commissioners saying, this is my thinking on this topic? Period, as long as it's not replied to, or is that to be avoided as well?
I think it's to be avoided, but I understand it does happen. I think that, well, I'll get to the public record issue, but it more pertains to what can and cannot be FOIA'd. So all communications are subject to FOIA. So we just need to be very mindful about what we're putting out in the world and what we're asking people to do.
Lisa, real quick, you made the comment that public officials. It's not just it's like any of us that are on a committee or a commission, it applies to us too.
Yes. Yes.
Just want to make sure that was
You're on Parks
clear.
and
Yeah.
Shade Tree, yes.
Yep. Yep.
Yes, your entity needs to follow all these rules as every other entity. Now, truthfully, if you were to email Commissioner Gallanti, have at it,
Right,
right? I mean, you're not conducting business, you're just simply letting him know something.
right.
Just use nice words and stuff in your email.
So
Okay.
I will try to bring the microphone around so we can capture the questions from
Oh, good.
folks
I'm
in the
sorry.
audience on the recording.
Thank you. Okay, well, we're going to take a little beach break. Pretty pictures. Okay. Think of the warm summer days. Okay. Executive sessions. I'm going to say this here for everybody and the millions of people watching from home. Executive sessions are not bad things. They get a very, very bad rap. But there are appropriate reasons for entities like the Board of Commissioners, for example, to go into executive session. We have to stop believing that everything that goes on in executive session is secret just to be secret. That's not what it is. Executive sessions, when necessary, are in contravention of the public policy of the open meeting laws, but allowed by statute. We must closely scrutinize them to assure that they are for proper reasons. That is why reasons for executive session are printed clearly in the agenda. They only are permitted if they fall under the categories as listed. The big ones. Discussion of an individual citizen's qualifications to hold a job or pursue training unless the citizen requests that such a meeting be open. Strategy sessions, including those involving legal advice or opinion from an attorney at law with respect to collective bargaining or pending or potential litigation, but only when an open meeting would have an adverse effect on the bargaining or litigation position of the public body. The discussion of a citizen's qualification does not apply to an individual when they're trying to get issued a license. Potential litigation is one that we use a lot because litigation is sometimes likely or foreseeable. You have to be clear, though, what likely or foreseeable means. For example, we should look for objective signs that litigation is coming. Someone stands up and says, "I'm going to sue you." It's pretty objective. A written demand letter in which a claim is asserted or action is demanded may give rise to a proper inference that litigation will soon follow. Other indicators of potential litigation might include previous or pre-existing litigation between the parties, or proof of ongoing litigation concerning similar claims, or proof that a party has both retained counsel with respect to a claim at issue and has expressed an intent to sue. If we are going to be talking about legal theory or practical realities associated with litigation, we can do it in executive session, and that's okay. We have to be able to point to a realistic and tangible threat of litigation, excuse me, so that it can be part of executive session, but it is allowed. Also, a discussion of the content of documents excluded from the definition of public record, where such discussion may disclose the contents of such documents. The hearing of employee disciplinary or dismissal cases, unless the employee requests a public hearing, and a personnel matter in which the names, competency, and abilities of individual employees or students are discussed. Executive session rules. Minutes must be taken. The governing body must vote to hold an executive session. They have to vote to go into executive session and out of executive session. The executive session must be on the agenda and with specific statutory basis for the executive session. Can't take any votes, no straw polls, and you have to only discuss what the executive session topic is. I want to really be clear that we need to dispense with this myth that executive session is bad, because the reason and the rationale is given, and I think that since I've been here, we have done it for valid reasons and been appropriately in executive session. Public records. We talked about public meetings, open meetings, and documents. We are at part 2. Anyone asleep yet? Public records are defined by statute as information of any kind owned, made, used, retained, received, produced, composed, drafted, or otherwise compiled or collected by any public body relating in any way to public business or in any way of public interest or in any way related to public purposes, regardless of the physical form or characteristic by which such information is stored, recorded, or reproduced.
Question on that.
Yes.
So I'll use the example, if I send an email to one of the commissioners, to all the commissioners, and Chris Galante replies to all, is that a public record now?
It is a public record the moment you email commissioners. You just said when you email
Yeah.
commissioners.
If I hadn't had a thought, yeah, okay.
It is a public document the minute you have emailed commissioners.
And are all those, every one of those printed for meetings that we have? Are all the emails that we send to commissioners part of that record?
If you are providing public comment before a meeting, correspondence, that goes into the agenda, yes. And that is obviously public record, yes.
But ultimately, if it's not something that's put in the agenda, someone could file a public records request and get that from the city if it's a responsive record to their request.
Yes. Exemptions regarding what a public record is are very narrow and are generally very narrowly construed. Thus, and this is a big one, assume everything that is written will end up on the front page of the newspaper or on a troublesome website. Please, can we all say it out loud? Assume everything that is written will end up on the front page of the newspaper or on a troublesome website. One more time. No, I'm just kidding. Please, I'm begging you, when you write an email, think of it as my grandmother used to say, I don't want to read about you, Lisa, on the front page of the news journal, so will this end up on the front page of the news journal? Obviously, this was a long time ago, the news journal. But please, when you write something, say to yourself, if every one of my neighbors read this, what would they think? And, I need to be honest, generally speaking, the Cape Gazette here, it could very well end up in the Cape Gazette. And that is an entirely logical and realistic ending. It also may end up on a troublesome website or, anywhere. So please, voicemails, emails. One more time. Assume everything that is written will end up on the front page of the newspaper. Sorry. Really? You have a question?
One point of reference, and also realizing those emails could be forwarded. So it's not
Yes.
to the intended recipient, but that recipient then, even though you have a disclaimer on the bottom, it can still be forwarded.
Regular emails can, not my emails that come and say privileged and confidential, but yes, that is fair. Okay. Non-public records, the ones that we cannot give out, personnel, medical, just disclosure of which would constitute an invasion of personal privacy, trade secrets and commercial or financial information obtained from a person which is of a privileged or confidential nature, investigatory files for civil or criminal law enforcement, including pending investigative files, criminal files and criminal records from our police department, intelligence files compiled for law enforcement purposes, the disclosure of which could constitute an endangerment to the local, state, or national welfare and security, any records pertaining to pending or potential litigation, which are not records of any court, meaning that you cannot use FOIA for discovery purposes. And then, executive sessions. Any records which disclose the identity or address of any person, meaning, holding a permit to carry a concealed deadly weapon. Any records of a public library which contain the identity of a user in the books, documents, films, recordings. Emails received or sent by members of the Delaware General Assembly or their staff, and any communication between a member of the General Assembly and their constituents. Everything else, however, is a public document. We don't have to create a document for a FOIA request, but if we get one, a FOIA request, and we have that document, it is very, very difficult, assuming redaction of people's, addresses and phone numbers and things like that, for us to preclude it from going out. That includes those emails where you describe your neighbor as not a very nice person. Okay. Records, Anne and Marco do a great job of making our records open for inspection during normal business hours for those that we cannot by email. We have a FOIA request on our website. They must be in writing, and we would ask anyone who is FOIAing anything to be as specific as possible. It is very difficult for us to get a FOIA request that says, I want these documents going back from 2002 to now. Right? What do you want? How do you want it? Let's give us the issue and we'll try and get you what you are actually looking for. We can charge for FOIA, which is good because it costs a lot in time and money to get documents out. And the Attorney General's office, as I said before, is the arm that monitors and enforces FOIA, meaning that if someone believes that we did not comply with a FOIA request, they can appeal our decision to the Attorney General's office. We all know that Rehoboth has been the subject of FOIA inquiries before. We are trying really hard, knock on wood, not to do that anymore. You all can help that by complying with everything that we've now discussed. The court may award attorney's fees and costs for the failure to produce records in a FOIA suit, so it actually does have very significant implications. Quiz time. You get ice cream, Commissioner Gossett, if you get it right. Can public comment be limited? Yes. Ice cream for everyone. Does FOIA require public bodies to answer questions? You guys are amazing. Does a confidentiality clause in a settlement agreement exempt the settlement agreement from FOIA? Tricky one. Oh, you guys got them all. Can a public body go into executive session to discuss interview questions? No. You can discuss the competency of the individual. You can't discuss interview questions that you're going to ask. That's okay. I'll say you got them all right. It was a trick, yeah. Okay, another boardwalk break because, yes.
Can commissioner comment be limited?
Yes.
Then why don't we? No, I retract the second.
There are no regulations regarding commissioner comment. Okay. We have to talk about ethics, and this is the part where I just want you to remember a very simple statement. It is the appearance of impropriety. It is what is the perception to the outside world, because this is subjective. So remember, appearance of impropriety. The Public Integrity Commission exists in the state of Delaware, and they govern the ethics of elected officials, individuals in government. The purpose of the Public Integrity Commission to ensure proprietary public respect and confidence by setting specific standards of conduct for state personnel, government employees, without unduly circumscribing their activities. It applies to all local governments unless they adopt their own code of conduct, which the city of Rehoboth has not. Members, there are 7 members appointed by the government, no more than 4 of the same political party, and appointed for 7 years. Individuals appointed to the Public Integrity Commission cannot themselves hold elective office. And a quorum requires 4 members present. What they can do: they can recommend rules of conduct, issue advisory opinions, investigate through counsel, hold hearings, and take or recommend disciplinary action, maintain records, follow the rules, subpoena witnesses, prepare manuals and guides, and administrate and implement financial disclosure provisions and lobbyist registration provisions. What they are governing for is a conflict of interest. What is a conflict of interest? I go back to my earlier statement, which is the appearance of impropriety. A conflict of interest: no employee official may participate in the review or disposition of a matter with which the employee official has a personal or private interest. A personal or private interest is an interest which tends to impair a person's impartial judgment in the performance of their duties. Oops. Okay. Impairment of judgment occurs where the employee, officer, or a close relative will receive a financial benefit or suffer a detriment to a greater extent than would accrue to other members of the same class. If that were to occur, delegate the responsibility to someone else, or if you are unable to do that, you have to provide written notice to the PIC, fully disclosing the interest and why the duty cannot be delegated. That is, if you're on the Planning Commission or the Board of Commissioners. No employee officer may represent or assist any private enterprise with respect to a matter before the state agency with which the employee office is associated. Generally speaking, those who are on the Planning Commission cannot be part of developer organizations, things like that. These are the basic, simple ones, but just to be clear. No officer may assist a private enterprise with respect to any matter before the state, city, or town. An employee officer may assist a private enterprise in the exercise of such person's official duties. An employer, officer, or enterprise in which the employee officer has a 10% or greater ownership interest shall not contract with the state. Please don't do that. An employer officer shall not represent or otherwise assist any private enterprise on a matter involving the state for a period of 2 years following termination of employment with the state. If that employer officer gave an opinion about it, was investigated, or was directly and materially responsible for the same matter during their employment. This generally occurs when someone leaves state government and goes off into the private sector. They can't represent before the state agency. Do not disclose confidential information, including, but not limited to, disclosure statements of financial interests, applications to the PIC for waivers of requirements, or proceeding related to a violation of these rules. That is where, if you are in executive session, you cannot disclose the information. That is one of the admonitions before executive session. You cannot disclose what you learn here. If you disclose information learned in executive session that you are not entitled to, that is a direct violation of a conflict of interest statute before the Public Integrity Commission. Just to be 100% clear. Our code of conduct, again, we've adopted the state code of conduct. Act in a way that does not make it appear you're violating public trust. I'm sorry, this is one of those that just seems, basic, but I'm telling you, avoid appearances of impropriety. Do not obtain interest in enterprises which are in conflict with the performance of your duties. Always be mindful of how it looks, what the perception is. You may not be doing anything wrong, but the perception taints the ability of our government to run effectively. Do not accept gifts, compensation, or payment of expenses where it could appear that it impairs your judgment. Don't take $1 million from somebody. Results in preferential treatment to a person, results in governmental decision, or adversely affects the confidence of the public. Avoid financial interest in private enterprises which may be directly involved in decisions you make in your employment. Do not use your office to secure unwanted privileges, advancement, or gain. And do not engage in activity which may cause disclosure of confidential information or disclose confidential information or use sexual favors as condition for favorable treatment. I'm sorry, but we have to include all of them. Okay. If you feel as if there is a conflict of interest, or if I or any of the other attorneys for Planning Commission or Board of Adjustment approach you and say, I believe that there is need for a recusal. You have publicly come out against a project, or you have a financial interest in something. A recusal will be requested, meaning you will not be permitted to engage in discussion or a vote on a particular topic. But the reason I'm adding this in is that the failure to recuse has real-world implications, and there have been some cases. I can send you all blurbs about every one of them. But the bottom line was that the decision of one individual is imputed to the entire entity. So if the Board of Commissioners were to make a decision and one individual did not recuse and was found to be in violation, then the entire decision of the Board of Commissioners is called into question. So when or if me or Fred or Bill or someone approaches you and says, we need to talk about recusal, recognize that we're doing it because it is imputed to the entire entity. If you do have an issue, a conflict of interest, something that presents itself, we can request a waiver or ask for an advisory opinion. I would just urge you to, speak up. Again, counsel on all of the commissions. I'm here for the city and Commissioner Saunders and Commissioner Thier's committees. Should something arise, please do come and talk to us, because we'll need to file a written request for both waiver and advisory opinions and wait for the Public Integrity Commission to make a determination. The mayor doesn't like when I talk about the PIC, so I'll just move quickly to the complaints, hearings, and disposition section. They can initiate a complaint on their own, or if initiated by a third party, it must be a sworn complaint, and they can dismiss it on their own if it is deemed frivolous or fails to state a violation. They can do hearings. You have the right to notice an opportunity to be heard, legal counsel, witnesses, and appeal to the Superior Court should you not like the decision of the Public Integrity Commission. If the Public Integrity Commission determines a violation has occurred, it may issue a written reprimand or censure of conduct, and non-elected employees may be removed, suspended, or demoted, and those that are elected officials, a sanction can be a recommendation of a removal from office, depending on the severity of the violation. Improperly accepting gifts, employment, compensation, or anything of monetary value, misuse of public office for private gain or unwarranted privilege, or improper use or disclosure of confidential information can get you administrative sanctions. Oops. Damn, I went so fast. Oh no, we gotta start again, sorry. Okay, still awake? We're done.
All right. Can I add? Oh, thank you. A question, just something you said, and I'm not sure whether you meant it the way you said it, but you said if you've taken a public position on something, you might be required to be recused.
Yes.
So I mean, what if you're an advocate for the homeless and a homeless issue came up? Does that mean?
No. I'll be more specific. If you are a member of the Planning Commission and you determine that you'd like to go before the Board of Adjustment to take a position on a matter before then, and you were to stand up and say, my name is John Smith and I'm on the Planning Commission and here's what I think, right? So don't do that. Exactly. Don't do that. But no, you as a private citizen are permitted to advocate away.
And I think another example of that is, let's say before you're a planning commissioner or before you're a city commissioner, you speak out against a certain rezoning project, something like that. And then you're on planning commissioner, board of commissioners after some time, and it comes before you, and because you are in your capacity as a private citizen, you most likely would have to recuse.
Depending on what you've said. I generally, when people have asked, for example, can you do that as a private citizen? Can I stand before, I'm a Board of Commissioner member, but can I go before the Planning Commission and tell them why I don't like what they're doing? I generally say you can as a private citizen, but should that then come back to the Board of Commissioners, you've now put yourself in a difficult position.
I'm sorry, one more question on this. So when
Only
I
one.
asked earlier if I emailed the entire, all 7 commissioners, or commissioners and mayor, and then that's a public record. So if I email one commissioner and he responds just to me, is that a public record?
It is.
It is.
It is.
But it's not for, well, it's not, you haven't violated anything.
Oh,
'cause
no,
you're
no,
in a
no.
quorum.
You haven't violated anything. I mean, the idea of being able to communicate with your elected officials, we certainly, that's where kind of FOIA is complicated because we don't want to stifle that. Of course, we want to make that more accessible. Transparency and open government. However, just so you know, your email then becomes a public record. And if your neighbor doesn't like you and wants to FOIA emails that you've sent, I have absolutely no authority to say no to that.
Correct. But that, it's a public record, but everyone doesn't have to be printed every time unless
No.
someone asked for it.
Absolutely not. It's only those that are requested.
Okay, thank you.
And I think that's really the issue, that what I'm trying to stress is that you are more than welcome to email, call, leave voicemails, whomever. But if somebody asks for them, if somebody from the public requests them, they are public documents, they are public records, and it would be very, very difficult for the city to say, nope, we're going to hold on to these. And I always tell people that if you start your email by saying something terrible about your neighbor, or, I hate so-and-so, or whatever, and you make stupid statements in your emails, I can't redact that. That just goes out into the world. So be mindful and professional when you are writing anything, because you don't want to see it on the front page of the news journal. Any other questions? I went quickly because this is not so exciting, but I really do need you all to pay attention and remember. And if you have any questions at all, if something arises, you can call me, you can call Bill Larson if you're on Planning Commission, you can call Fred Townsend if you're on Board of Adjustment, or, email Taylor, whatever, however we can help. Done. You are welcome.
There's a sign-out sheet by her corner of her desk. If you haven't signed it, please sign your name. Thank you for coming.